This is the DC Bar's Brief Encounters podcast. I'm Don Resnikoff, member of the DC Bar's public interest and courts community. Our topic today is making litigation less complex, more efficient, and just. We'll be speaking today with retired judges Thomas Moukawsher and Bennett Rushkoff. From 2013 to 2023, Judge Moukawsher served as judge of the Connecticut Superior Court. He is the author of a well-regarded book called The Common Flaw, Needless Complexity in the Courts and 50 Ways to Reduce It. The book critiques the complexity of modern litigation and judicial practices and proposes a series of suggestions to bring greater efficiency to court proceedings, as well as greater public respect for the courts. Since the publication of The Common Flaw, the judge has become a regular commentator on legal issues for national news sources, and his work appears in an array of well-known publications. We also have with us today Bennett Rushkoff, a retired administrative law judge in D.C. He currently is on the D.C. Bar's Board of Governors. Previously, he was an administrative law judge serving on the district's central panel of administrative law judges, where he specialized in public benefits cases, including cases involving Medicaid eligibility and coverage, food stamps, emergency shelter, and other assistance programs. From 1998 to 2016, Judge Rushkoff supervised most of the district government's leading affirmative civil cases in the D.C. Superior Court and federal court, and personally conducted much of that litigation. So, both of our speakers have great experience in what it takes to make litigation less complex and more efficient. My own experience includes a senior management and litigation role for the U.S. Department of Justice on the U.S. v. IBM litigation, which is well known for being pursued for many years. Later, I represented D.C. in the lengthy U.S. and multi-state antitrust litigation against Microsoft. So, like our speakers, I'm familiar with the problems of complex and lengthy litigation. Turning to Judge Moukawsher, first, thank you very much for being here today. And a major theme of your book is how individual judges can manage cases in ways that reduce complexity and increase fairness. And I'm going to start, if you don't mind, with a brief quote from the book, which will sort of set the tone. The quote is this: "Replace the formalism that prevails in court with a kind of humanism that decides cases promptly, more on the facts than the law, more for the parties than the lawyers, more for the consequences to the people and the public, and in words we can all understand." And that ends the quote. And turning to a question, why is it so important, in your judgment, to reduce the complexity of court proceedings, and what do you believe is at stake in that?
Well, first on, thanks very much for having me on, and it's a real pleasure to be here with you and with Judge Rushkoff. I appreciate your interest in my work. I think the question you ask is the big question here, and I think that we all are talking today about the threats to the rule of law, the importance of respect for the rule of law, the diminishing respect for the rule of law. But I think a simpler way to put it is, let's face it, the public hates us. And I think that that is a very dangerous thing. It is both bad for the continuation of our institution, which have been undermined in terms of the public respect. But I also would remind lawyers out there that it's a very bad business plan for people to want to have nothing to do with you. And so I think we have to build faith in our institutions. I think we can build faith in the institution of the law and the courts by making them function in a way that's focusing on the people who are coming there. And this is where I mean about humanism versus formalism. Formalism is the case is all about itself, and those with litigation experience know that the case is mostly about itself. But at the core of every case is something more humanist, something more about a right and a wrong, something about lying, cheating, stealing, injuring, breaching promises. Those are the kinds of things that are ultimately at the core of a case. And that's what the public wants us to get at. And their frustration with our system is that we don't get very near it most of the time. And most cases, as everybody knows, 99% never get a trial, never get to address that core issue. And instead, it's a contest of beating each other up and then accepting a settlement that nobody likes. And that's why I think what's at stake here is so important. We've got to build faith in our institution, or maybe we're going to lose it.
That makes a lot of sense. Would you share with us some of your thoughts on what individual judges can do to make litigation a better experience and reduce complexity?
Well, I think I draw the contrast between a dynamic style of managing cases and a static style of managing cases. The static style predominates in court. Judges see themselves as a kind of innocent bystander in litigation where they, show up and the lawyers ask for this and that, and they respond to it. And if the lawyers don't do anything, a case just sits and rots. And if the lawyers don't push them in one direction or the other, the judge doesn't react to the case, and judges allow the cases to stack up and pile up. A dynamic style, on the other hand, is a matter of leadership. And I think that the judicial system needs leadership. And I think lawyers, because I've spent years doing this approach, respond to leadership. And a dynamic management style means that the judge leads and just doesn't stand by. The judge calls the parties in early. The court gets the parties to discuss the key issues and key events right away. And the judge keeps up with the case. The judge keeps the case moving. And the judge responds to the needs of the parties and the lawyers promptly, because motions tend to stack up and judges delay in deciding them until someone really pushes them to do that. But being accessible is a very important part of dynamic management. It's not all about judges pushing lawyers around or something. It's being responsive to their needs and to the needs of their clients. And certainly when I was doing complex litigation on the bench, that's what I would do, is make myself available to lawyers and not just simply make them be available to me. It's got to go both ways, but that's a dynamic management style. It's different from the typical static style that stands by and waits for the lawyers to do something or ask something.
Oh, you've mentioned the lawyers in this context too. And can you turn to what lawyers can do to reduce complexity and how that fits with the lawyer's role? I mean, presumably the lawyer wants to be zealous, and sometimes being complex might seem, to the lawyer at least, a way to accomplish that goal. But you say a word or two about the lawyer's role.
Well, I'll be shamelessly blunt about what I think the legal profession has to do to help us get out of this mess. And I would ask people they'll have their immediate reaction of horror. And then I'd ask them to think thoughtfully about it over time and see if there's a way out of this mode we're stuck in. And that is, if they could do one thing, in my view, it would be to kill the billable hour. I think the billable hour drives needless complexity in the courts because it creates a divide between the interests of most clients and the interests of lawyers. And it's often an unconscious divide. It's just that the business of a law office revolves around billable hours and business origination and collectible hours in most firms, in the firms that are often in complex litigation. And so it just naturally tends in that direction toward complexity, to filing of more motions and the rest of it. I think that it's a bad business strategy, as needless complexity is generally a bad business strategy, because everyone works to try to avoid hiring a lawyer. And if hiring a lawyer were more efficient and cost effective, they'd hire more lawyers. So you could actually increase business if you had a different model. And I laid out a model for that in my book, in which you start with a basic flat fee and you create incentives to try and win cases. Let's say you're defending, you get a victory bonus for ending a case earlier and earlier in the decision. And you can work out flat fee approaches no matter which side you're on, and a kind of contingency approach that incentivizes. But I laid all that out in my book. But I actually do think that's the biggest problem driving needless complexity from the lawyer standpoint. Another piece of lawyer advice I would give is to please write for and advocate for the judge. Right? Remember, know your audience is what they tell you early on in any sort of public speaking, and aim at your audience, aim at the judge. It doesn't hurt to know something about the judge, but I'm just saying write for the judge. Don't write for your managing partner by making it longer, making what you're doing longer. Don't write for your insurance company. Don't write out of fear. And don't write for the Court of Appeals, because everybody knows that your chances of winning any case on appeal are very small. So try to win in front of the person you're dealing with and write for that person, advocate for that person, know and understand that person, and win in front of that person. And then you realize that you can cut out a lot of what you're doing and get right to the heart of the thing that will capture the judge's attention, imagination, and support. So I'd say those two things are the biggest ones I'd point out.
Yeah, I must say, I myself have experienced cases where technology was involved and the lawyer would talk to the judge in a way that would cause the judge to turn to him and say, you know what? I don't understand anything you said. So they could have done better and realized that they have an audience and the judge and bolded what they had to say accordingly. Now, I want to move on to the point that both in your book and in your comments here, you've emphasized that a dynamic judge can take control of things and make the litigation be much less complex, much more efficient, and more just. But that would raise a sort of a question of whether or not proposals that would change court rules and have judicially imposed procedures have a useful role in streamlining litigation. I'm thinking, for example, of rules which I think have been proposed and used in some jurisdictions that would limit discovery procedures like interrogatories, depositions, and motion practice. And I understand your point to be the judge can do that. The dynamic judge can do a lot of that. But would revision of court rules to require limitations be helpful and important in your view?
They would probably be helpful, but they're unnecessary because the federal rules of civil procedure and most local courts rules provide ample latitude for a judge to dynamically manage the second biggest obstacle to efficient trials, and that's discovery. And for years under the Connecticut rules, and the federal rules are even stronger on this, I used the discretion that was granted to the court to dynamically manage the discovery process. And here's what I mean by that. At the very first meeting of the parties in the court, I would begin first by just seeing if there's anything that would stop discovery, like a subject matter jurisdiction claim. But I would get to discovery in that first discussion and dynamically manage discovery from then on. And I would do that first by saying, well, what kind of a case is this? All right, it turns out it's a contract case. And so, all right, I know that both sides are going to want copies of all the drafts of the contracts. They're going to want all the communications about the contracts. They're going to want all the documents that are evidence of damages. They're going to want certain other things. And then I would say these things to them on the record, and I'd be typing madly to write out an order that covers those things. And then I would ask them, what else are you going to want? And the parties will tell me what else they're going to want in terms of documents. And I would write those down too. And of course, there might be objections, and I might resolve those on the spot. Or if they're very, very complex, you just say, well, we'll do another thing next week where we talk just about that one issue. But all the things that we can get over with in that first conference, I would order day one that these things would be exchanged. And I would also order the parties not to serve interrogatories and production requests. You don't need them. You've got me. I've just issued the production requests. And if you wanted answers to certain questions, obviously, I would include those in the order as well, that the party will answer whatever it is. And then I would tell them, and this is where the judge helping the lawyers comes in, is that if you have trouble with these things and you need additional discovery, or you have a dispute over what I've ordered, just let my clerk know. I'll see you tomorrow morning. And I was trying cases almost every day on the bench. But every morning, at 9:15, and every afternoon at 4:30, I would talk to lawyers who have discovery disputes. When the judge is going to be directly involved, the number of discovery disputes drops incredibly because they know they're going to have to say this to the judge, not just to each other. And they can give each other all the usual nonsense that goes back and forth in discovery, but they usually don't want to say it to a judge. And so most of the disputes go away. And I find that the rest of them can be handled in a 10 or 15-minute conference. Yes, of course, sometimes you have longer ones, but 90% of them are short. So that's the first thing. And the most important thing is discovery. Serial motion practice, a judge managing serial motion practice would be the next thing that I'd argue. In other words, put your motion to dismiss for failure to state a claim along with the increasing number of subject matter jurisdiction and personal jurisdiction claims, put them in a single motion. Obviously, if there's no subject matter jurisdiction, I don't need to get to the part about your cause of action. But if I do find I have subject matter jurisdiction, I can get all of these resolved in a single motion, and parties strategically or traditionally string these out into multiple motions. And a single motion could take a couple of years. I have seen in some courts it'll take a couple of years because of briefing extensions and trying to get the oral argument down. And then many times the judge will take, judges in federal court have essentially an unlimited amount of time to decide them. Some of them take years to decide motions. In Connecticut, we had 120 days, and judges sometimes routinely took 120 days. I tried to get decisions out and things like that in about a week. And I think it's very doable if you're focused on the real issues. But serial motion practice would be the next thing. Third point, trial admissions. And I do explain all these things in the book, and some details have to be left out here. But I found trial admissions enormously useful in cutting down on the usual 920 exhibits that are put in even a moderate sized case. You don't need exhibits to prove things that aren't going to be disputed. What was in a bank account? It's never going to be disputed. I don't need the bank account. The parties should simply admit that this bank statement says there's $900,000 in the account. What the account statement says is never the issue. What happened after that, like somebody took money out, so you had a statement that shows $900,000 on one day and a statement that shows $100,000 the next day, it's not going to be a dispute about the statements. You don't need them. You need a stipulation that it showed 900 on day one, 100 on day two, and then the question becomes, what happened to the money? Not what does the document say? And you don't need to lay the foundation for its authenticity, et cetera, et cetera, et cetera. And there's a million things like that, like the contents of emails. The contents aren't disputed, their meaning usually is. Same things with texts, et cetera. But all kinds of documents, most documents, don't need to go into evidence because they prove something that isn't disputed. Even medical records, what the medical record says, et cetera, isn't going to be disputed. So you just get this list of trial admissions, and they cut the length of the trial down by about 3/4. And the judge oversees that process and works with the parties. They're not served like discovery requests. They're served on an order of the court to do it and supervised by the court, because most people's experiences with admissions are about as frustrating as their experience with interrogatories in production. Final thing I'll say is time clocks. I first had one imposed on me by Judge Bill Alsop out in the Northern District of California, and I was upset with it at first, and I came to love it, and I used it. It works. And virtually every trial I used it with, the parties ended up with extra time. So those would be my key points, I'd say.
Well, thank you. I think your discussion of the engagement of the judge with the lawyers leads naturally to a question for Judge Rushkoff, whose experience is in a court where the involvement of the judge is going to be very great just by nature. And in particular, I'm going to ask Judge Rushkoff to talk about how the DC Office of Administrative Hearings addresses issues of complexity, and especially how the ALJ's use of status conferences in cases, especially where they're pro se litigants, how that helps sort of form the litigation and control the litigation that's going to follow.
Oh, thank you, Don. And first, I just want to thank you for including me in the discussion, and I want to thank Judge Moukawsher for participating. In my work at the Office of Administrative Hearings, I focused on public benefits cases where we had primarily pro se litigants, and even the government was usually not represented by an attorney. And we really had no choice but to be dynamic, to use Judge Moukawsher's term. In these public benefits cases, we had status conferences that largely replaced the normal components of civil litigation. Like I would say, replace the complaint, the answer, discovery. You start a case at OAH with a hearing request. Okay. And a hearing request is really just a request for relief. It doesn't have to state a claim. It doesn't have to, properly plead anything. A hearing request can simply be turn my SNAP benefits back on, something like that. And so at the initial status conference, I would question the petitioner and try to, ask basically, what is your claim? Explain your claim. What facts support your claim? And I would then determine, are any of the facts in dispute? So perhaps the beneficiary's income is in dispute. So what can we do about that? Can the beneficiary produce copies of her pay stubs, for example? Or maybe we would determine that the facts really are not in dispute, but the beneficiary's eligibility is in dispute, in which case we might ask the government to produce its calculation to determine what the level of benefit should be or whether the person was eligible. So in this way, we work through the issues and we determine, whether or not the case can be settled or resolved or whether we have to schedule a hearing. And what I've been thinking about and listening to Judge Moukawsher is the extent to which some of the things we do because we have to with pro se litigants could perhaps be adapted in a court of general jurisdiction for use with attorneys.
Judge Moukawsher, would you comment on that? Is there something to be learned in the general civil court from courts like Judge Rushkoff's or even small claims court, where procedures necessarily are more informal and the judge necessarily has a very important role?
Well, I think Judge Rushkoff is exactly right. And it's exactly the way to approach it is to get those issues that don't need to be on the table off the table. And yeah, I do think it applies in every case. And I did complex civil, complex family. I did every sort of case, criminal cases, housing cases, and this sort of thing works always if you start with trying to get at the humanist core of the case. There's something someone wants. In Judge Rushkoff's case, it's a question of whether someone's entitled to benefits, not whether they pled something the right way or filled this out the wrong way. It's a question of what is it about these benefits and what is the size of any benefit that might be owed. And that's the core of the case. And I'm not saying that, procedural challenges shouldn't be considered. I'm just saying that they shouldn't be the entire case and they should be dealt with together swiftly and move on from there. So I think he's doing exactly what we're talking about here.
I'm going to ask Judge Rushkoff another question about motivations of lawyers, partly because he wants me to ask the question. And that is, it's sometimes said that complexity is the friend of the corporate lawyer defending large civil cases, particularly where the defendant's position is weak. In other words, the incentive for the person with a weak case is to raise a lot of dust and create complexity. And can that suggest that complexity can be difficult to discourage where there's that sort of motivation? So I'm going to ask Judge Rushkoff first to comment on that, and then I'll go back to Judge Moukawsher and ask for his comments.
Well, of course, in the government, as you know, Don, I was on the plaintiff side. So my challenge was dealing with unnecessary complexity created by typically defense lawyers for large corporations. But, of course, complexity is probably could be the friend of either side. So we're all familiar with the plaintiff that has a weak case, so drafts a very long complaint raising every claim or count imaginable in an effort to try to extract some nuisance value settlement from the defendant. And I think, to kind of echo Judge Moukawsher's point, these are the kinds of things that cause people to lose faith in the justice system. The idea that you can't get justice because a large corporation will delay forever, or that, someone who is, has a tendency to litigate frivolous cases can extract settlements out of corporations or people who haven't done anything wrong. That really goes at the heart of the legitimacy of our judicial system. So I guess the answer is, I think there will always be people or companies that see complexity as their friend. I think lawyers, I think in my career as a government lawyer, I tried to deal with this by having very focused complaints and very focused discovery. And of course, trying to use motions for summary judgment where appropriate. It really helps either the plaintiff or the defendant who is looking to get at the issue in the case and to get the case resolved. It really, I think what makes all the difference in the world is having an engaged judge who is seeking to have the case decided on the merits, and basically the judge becomes the ally of the side. Not literally the ally, but the judge is engaged enough in the case to help the side that's seeking to get the case, decided on the merits, to help that side get to the merits rather than remaining, unengaged and letting the case just languish.
Judge Moukawsher, can you supplement those comments?
Yeah, I agree with Judge Rushkoff that what's become of cases, as I think I mentioned earlier, is that they're about beating each other up, dragging the case out as long as possible, making things as complex and painful for the other side as you can, and then coming up with an unsatisfactory settlement. The lawsuit itself is often the punishment from the plaintiff's standpoint. And as Judge Rushkoff pointed out, on the other side, you can make the other side trying to sue you suffer so much that they'll give up for some nominal sum of money. It's a problem on both sides. And I think lawyers should be urging judges to take a more dynamic management approach to cases to end this so that litigation can be more satisfying for the parties in the cases, the people we're all supposed to be trying to serve, as opposed to simply using them as vehicles to, discredit our system, frankly.
Thank you. I'm going to move on now to a slightly different topic from your book, simply because I think it's really interesting. And that is your book's discussion of process-centered thinking, I think is your phrase for it. And in the book, there's a discussion of a case that involves Judge Alito, but you brought to my attention, Judge Moukawsher, that you wrote an article recently having to do with a recent case where the same sort of process-centered thinking was a problem. And I wonder if you could tell us something about that concern of yours.
Well, if you ever want to see the problem with formalism versus humanism in legal decision making, look at the recent NIH versus American Public Health Association decision written by Justice Amy Coney Barrett. This is a question of, at the heart of it, the separation of powers, the power of Congress over the power of the purse, the president's cancellation of congressionally authorized spending. That's what the case is about. The decision has nothing to do with that, never gets within a mile about it. It's all about whether the parties in the case should have filed their claims under the Administrative Procedure Act or the Tucker Acts. The court split down the middle, 4-4 on this subject, with 4 saying it should be the Tucker Act, 4 saying the Administrative Procedure Act. And Justice Amy Coney Barrett decided the case ultimately in what I think is kind of a spoof of formalism. She decided maybe it's both or maybe it's neither. And so what happened is she said you might have to bring a claim under one, but you may not be able to bring the claim under one. If you bring it under one, the Administrative Procedure Act, you might then have to bring it under the Tucker Acts. The decision went round and round and round, chasing the tail of the procedure, and never got within a mile of the question of great constitutional importance, which is the separation of powers and the power of Congress to control the power of the purse. And by sending it back with this messy procedural ruling, it effectively decided the case in favor of the administration's decision to cancel the spending, because it's going to be years before it ever gets back up to the Supreme Court. But it was not decided on its heart. It was decided on formality over humanity.
I think with that interesting and important point, we'll wind up our discussion here today. And I think it provided a great deal of benefit to the audience that will hear this. I will say on your recent article on this case you just discussed, I'm going to take steps to try to make that available. But again, I want to thank you both very much for participating and providing a lot of useful information. If this were on TV, I'd hold up your book and encourage people to buy it. And you told me that it's available not only in the hard copy that I have,
Yep.
but also in electronic version through Amazon and other sellers. Is that right?
Yes, The Common Flaw, Needless Complexity, and the Courts in 50 Ways to Reduce It. You can get it on Amazon in hard copy or also in Kindle.
Thank you both very, very much.